Understanding sexual harassment within the workplace is not that complicated if everyone undergoes the right awareness training by an accredited and certified company. We find that leaders and human resources seem to get this wrong all the time. I'm going to explain so everyone will understand when there is a case for sexual harassment. Every case is drastically different. Just because I say something in this video and it seems to be your factual situation doesn't necessarily mean that the law was broken. So if you have a specific question about a specific set of facts, please contact us. So what exactly is sexual harassment? I know definitions are boring, but they are very helpful. It's unwelcome, verbal, visual or physical contact of a sexual nature that is either severe or pervasive and affects the working conditions of the employee and creates an almost abusive working environment. Let me point out a couple of things to make them clear in your head. The conduct at issue must be unwelcome. I can't tell you how many times an employee has complained that they were sexually harassed in text messages, and when we finally reviewed the text messages, the employee is giving the harasser a winky face, laugh out loud, and "you're so funny" in response. It might be very difficult to convince an employment tribunal that you considered the harassment to be unwelcome if you're saying LOL when they say bad things. Secondly, the harassment issue must be severe or pervasive. What does this mean? Well, severe obviously means rape, sexual assault, or physical touching or grabbing that meets the severity test, but also pervasive, and that means more frequently, the conduct issue which was unwelcome happening again and again and again. Now to hold a company liable, meaning accountable legally speaking. Generally, employees have to show the employer knew or should have known about the harassment that was occurring, and that the employer failed to take any steps to prevent it from occurring. Hence why now the Worker Protection Amendment to the Equality Act 2010 Act 2023 has come into law. In the future, this is very important, but we'll go into more detail in that later on in this video. Verbal conduct. Obviously, what you say can constitute sexual harassment. Repeatedly asking somebody out, making sexual jokes or innuendos such as "that's what she said," I would avoid those. Obscene and foul language, commenting on how somebody looks or what they should wear, "you look good in that colour red." Those are very solid examples of things that we have heard many, many times that can, under the right circumstances, constitute sexual harassment. What about visual conduct? Well, the posters in your office, your screensaver, the things you send or just forward in emails, your social media posts, in certain circumstances can constitute as sexual harassment. Instant messages, and most importantly text messages. I can't tell you how often sexual harassment cases revolve around text messages. And finally, physical conduct. Well, obviously a physical touching, stroking, gesturing, patting, hugging, all of which can, under certain circumstances, constitute sexual harassment, but also staring and leering at somebody or blocking somebody's path, impeding their way out of an office are good examples of sexual harassment. I've had cases as serious as pushing someone over a desk and pretending to have sex with them. This is obvious conduct that can constitute sexual harassment if it meets the other elements of the test. Sexual harassment employment tribunals and settlements in favour of the employee can be enormous, as we see far too often in the press. So, when is the company financially liable for bad behaviour? As I've already talked about, it is when a company knew or should have known that the harassment was taking place. That's a little bit vague, so let's give you some real examples if harassment is being perpetrated by a manager or managerial employee. Any manager or employee, generally, the company is held automatically liable. On the other hand, if the harassment is being perpetrated by a colleague, somebody who doesn't have supervisory employee duties, then the company isn't automatically liable. However, they have a preventative duty to take reasonable steps to have stopped it occurring in the first place. But the company can be held liable if they had known about the harassment, if the company is put on notice. So how does that happen? If the complainant or someone else that complains to the company, preferably in writing, that the harassment is taking place, then the company is on notice that they have the duty to try and prevent the harassment from happening again in the future. Basically, the Worker Protection Act doesn't allow companies to bury their head in the sand and avoid liability by pretending they didn't know about what was going on. So now let's talk about retaliation. As you might expect, a lot of people who are victims of sexual harassment submit written complaints to human resources or their appropriate person within their company. That's good. If the company retaliated against the employee for submitting that complaint, then the law is clearly broken, because when a legitimate sexual harassment complaints are ignored, I'm going to take that a step further. I would argue that nothing makes an employment tribunal angrier than a company protecting the harasser over the victim. So if you are a human resources or a manager, make sure you take these complaints seriously. And if you're a victim and you haven't complained yet, complain in writing and do it politely. There is also another type of sexual harassment, which is called quid pro quo. It means this for that. In Latin, basically, this type of sexual harassment is when a manager or supervisor demands sexual favours in exchange for employee benefits, raises, promotions, or things of that nature. It's relatively a rare area of sexual harassment, but it still happens, and as you can imagine, it is very serious. If you're dealing with sexual harassment within your workplace, what action can you take and how much is at risk? Well, let's look at those two questions from two different perspectives. Firstly, employee. As the victim of sexual harassment, should you contact a solicitor? Well, unless a serious adverse action has been taken against you, by that I mean termination, retaliation or demotion, or they're actually putting the harasser in charge of you or in closer proximity to you after they know that you've accused that person of sexual harassment. I also recommend that you reach out to specialist experts if the sexual harassment issue is very severe and you know that you're a victim of sexual harassment. Now okay, what about if you are HR? If you've received a bona fide, legitimate sexual harassment complaint, what should you do? Well, we first recommend that you separate the alleged from the accused, and we recommend that you do a highly impartial investigation. Now, if you're not capable of being impartial, or nobody within the company is capable of being impartial, we recommend you hire one of our specially trained investigators to do it. Now, if the employee is being hyper-aggressive or making allegations, or if the investigation comes back and you find some merit to what that employee is saying, then I recommend you seek legal advice. I know that HR gets pushed around a lot, like ownership of companies, or by higher level managers, who think they know best. But you should push back and say, before we do anything, let's take specialist advice. So if you thought this video was helpful, please give it a thumbs up, and if you know someone who needs to hear this information, please share it with them. Remember, prevention is far better than cure, so why not contact our unique, highly skilled team of experts to promote the safety and well-being of your workforce, and together we can stamp out sexual harassment so everyone feels safe and is able to thrive within the workplace. Remember, this is law. My name is Olivia, and thank you for watching.